Hello all, welcome to UPSC Made Simple channel. Today we are going to start issue based mains preparation, and today's topic for that is Anti Defection Law. It will be very important from prelims perspective in mains GS paper 2, again for PSR optional and public administration optional. It will be very important. You will at least get one question in the prelims from this, because this is in the context of Maharashtra's political crisis, right? So it is very important. UPSC has already asked one question in the prelims when CM of Maharashtra joined the assembly as a chief minister without being a member of either of the house. That was the statement that was given in the UPSC prelims question itself. So this is very important. So we will just go through what broad aspects of this particular issue we are going to discuss. First we will see the context of this particular topic, anti-defection law. Then we will see what is the meaning of anti-defection or defection. Then what is the history of defection. Then we will see 52nd Constitutional Amendment Act, which brought 10th schedule. Then we will see rationale behind it, why it was brought this act and all. Then we will see provisions of this important act, then exceptions. Then we will see issues with respect to anti-defection. Then we will impact of this anti-defection on democratic setup. Then we will see way forward or what can be the possible solutions, and then we will conclude, right? So first we will start with the context of this issue. So for this context we need to go back to Maharashtra during 2019 General Assembly elections, Maharashtra 2019 elections. Before pre-election coalition was formed between BJP and Shiv Sena, led by Uddhav Thackeray, and BJP led by Devendra Fadnavis in Maharashtra. So there was pre-election coalition. After this, BJP won 105 seats, Shiv Sena won 56 seats. Then Nationalist Congress Party led by Sharad Pawar won 54 seats. Indian National Congress won 44 seats. Right? It was supposed to be a government of BJP and Shiv Sena, but Shiv Sena and BJP had some issues in between them and they couldn't form the government. Immediately, President rule was invoked by governor in Maharashtra, but after few days, on very early morning, people saw that Devendra Fadnavis from BJP and Ajit Pawar from National Congress Party, they sworn in as chief minister and deputy chief minister very early in the morning, right? But this Ajit Pawar from NCP couldn't gather much MLAs to form government. That's why after 80 hours, this Devendra Fadnavis and Ajit Pawar resigned from the chief minister and deputy chief minister. After that, governor invited other parties to form the government, and then it was Shiv Sena, NCP and Indian National Congress. They formed Maha Vikas Aghadi. Right? This is a coalition. This is a post-election coalition. And they ran government for around 2.5 years. But recently, in the last month of June, one MLA, Eknath Shinde, he was minister in this MVA Mahavikas Aghadi government. He took with him around 40 MLAs out of 56 Shiv Sena, and he joined BJP. Right? So now BJP plus this faction led by Eknath Shinde Shiv Sena, around 40 MLAs, and he had some 10 independent MLA support, plus they had some independent MLA support. Now they formed the government and they around gathered 175 votes, right? So now this is the government and Eknath Shinde faction of Shiv Sena has become chief minister of Maharashtra, right? So now there are lot of issues with respect to this. First issue is like the Shiv Sena led by Uddhav Thackeray or the remaining MLA, they used the power of the whip and they asked the speaker of the assembly to disqualify 16 MLAs of this Eknath Shinde group. So there is one case with respect to anti defection. There are other issues with respect to symbol of election, that is bow and arrow of Shiv Sena, who will get, whether Eknath Shinde faction will get or old Shiv Sena or original Shiv Sena led by Uddhav Thackeray will get. So again there are too many issues we will discuss. Next we will discuss the meaning of defection. What do we understand by defection? For example, we will suppose the one party A, other party B, and there are around 288 seats. Hypothetically, we will imagine this gets 150 seats, this gets 138 seats, right? Now to form government you need 145, right? And now getting 150, this A will form the government. But what happens? Around 20 MLAs from this party A, they join party B and now its strength become 158 and they form the government. But whether these 20 MLAs are allowed to join other party after the election or not, if they join this political party B, they will be charged under anti defection and they will be disqualified by speaker. This is called as defection. This is the meaning of the defection. If a particular member after getting elected on one political party, if he joins other political party, he will be called as defected and he will be disqualified from the membership, right? Next point we will see brief history. History of this anti defection law. The very famous case is Gayalal, 1967. What happened? This Gayalal from Haryana, he was an independent MLA. In the political turmoil, he changed his political party or changed his side 3 times in a day. That's why he became very famous. In Haryana that time, INC, United Front and Independent. So he was independent, he joined United Front, again joined Indian National Congress, again he joined United Front. So in a single day, he changed the party 3 times. That's why he became very famous. And after him, when Rao Virendra Singh became CM of Haryana, he was asked by the press, where is Gayaram? So then he said, the Gayaram is now Ayaram, that means Gayaram is with us, and that's why it became very famous, that is Gayaram Ayaram. And again the same term was used by YB Chauhan, then Home Minister of Central Government or India, and he used this term in the parliament itself and it became a parliamentary term. It went on the record. That's why it became very famous, Gayaram Ayaram, right? Now we will see 52nd Constitutional Amendment Act, and it was in 1885, and then Prime Minister was Rajiv Gandhi, right? And this was asked, this kind of question was asked already in the prelims once. When was the first amendment made? Who was the prime minister that time? Jawaharlal Nehru. That question was asked in 2019. So it is again very important. Now we will see rationale behind 52nd Constitutional Act. So what is the rationale? The main rationale or main aim to bring this 52nd Constitutional Amendment Act was to bring stability. Stability in the government or stability to the government by discouraging legislature from changing parties. Again, it wanted to curb practice of defection and punish them. This was the rationale or the intention behind 52nd Constitutional Amendment Act. Now we will see some provisions. Provisions of 52nd Constitutional Amendment Act. First, who has a power to disqualify a member of parliament or assembly. So power is there with presiding officer. He might be speaker or deputy speaker. He might be chairperson or deputy chairperson in case of Rajya Sabha. So presiding officer has a power to disqualify member on anti defection, right? There is again very famous case, Kohoto Holon, 1993. In this particular case, Supreme Court came out with two things. First, decision of speaker is not final, as when speaker sits for case of anti defection, he acts as a tribunal, and as all tribunals will have judicial review against the order of tribunal, there will be judicial review. So is the case of the speaker. When you will decide the case of anti defection, there will be judicial review. There will be judicial review available, right? But he said judicial review will be available mostly on two grounds. One is malified intention and second is perseverity. Based on this, anyone can approach Supreme Court for judicial review on a decision of the speaker in case of anti defection. This is Kohoto Holon case, right? Again, the first provision with respect to 52nd Constitutional Amendment Act is voluntarily someone gives up membership, right? If some member who is being elected on one political party and after getting elected he changes his political party or he gives up membership of that political party, then he is deemed to be disqualified under anti defection. But here you need to be very careful. There was one famous case of Sharad Yadav. After getting into election, he used to attend rallies of opposition. He used to sit with opposition, like he was against the government when he was inside the government. What he did not resign formally from his political party, right? At that time there was no provision with respect to whether someone will be defected or not if he do not resign, right? If someone do not resign formally, he will not be case of anti defection. This case went to the Supreme Court, and in Ravi Naik versus Union of India 1994, Supreme Court came up with very important verdict that conduct even outside house will be the base to charge someone for anti defection, right? And there is no need no need of formal resignation. That means if someone is doing anti-government or anti-political party activities, even outside the house, he can be charged under anti-defection, and there is no need to have a formal resignation of political party. So this is first case, voluntary. Second, whip. So what is whip? Whip is a MLA or a member or maybe MP who is assigned by that political party to take care of floor management. So he is nothing but floor manager. So his function is to ask the member to come for voting, be present, vote for some people or some particular issue or some particular bill. That is the whip. And office of whip is not mentioned in the constitution, and this was asked in one of the prelims. Office of whip is mentioned in the constitution. That statement is wrong because office of whip is not mentioned in the constitution. There are three types of whips. First is one line, second is two line, and third is three line whip. In one line they will just say there will be voting tomorrow. In second they will say there is voting, you have to be present. In third they will say there is voting tomorrow, you have to be present and you have to vote for this particular, maybe against the bill or with the bill, right? So if someone violates one line or two line whip, he will not be charged as a disqualified or he will not be charged as anti-defection. But if someone violates three line whip, then it can become a case of anti-defection, right? So this is with respect to whip. Then third case is of independent members. So what happens if independent member joins any political party? So if independent member after getting elected independently joins any political party, he will be charged as under anti-defection and he will be disqualified. But very important thing, if he joins government, he will not be charged under anti-defection and he will not be disqualified. Then fourth case is nominated members. What happens to the nominated members? There is only one condition, that is of 6 months. If any nominated member within 6 months joins any political party, he will not be disqualified under anti-defection. But after the expiry of 6 months, he joins political party, he will be disqualified as anti-defection, right? Got it? Now we have discussed almost all provisions of anti-defection law. Now we will see some of the exceptions. Exceptions to the anti-defection. First is a presiding officer. If a presiding officer, say for example speaker, or if he resigns from political party, he will not be charged anti-defection and he will not be disqualified. But again, very important thing, there is one condition. If he resigns from this political party and if he joins other political party, then he will be charged under anti-defection and he will be disqualified, right? Got it? Then second exception is merger, that is 2/3 members. Before this, we will just go through the earlier provision of split, that is 1/3. So before 91st Constitutional Amendment Act, 91st Constitutional Amendment Act 2003, there was a provision of split. It means if 1/3 of the members comes out of that political party, collectively they will not be charged as anti-defection and they will not be disqualified. But what happened with this 1/3 split condition? There used to be many defectors, there used to be many split in political parties, and there was lot of instability in the governments, right? So then government came up with 91st Constitutional Amendment Act and it removed this condition of split. Now you cannot split out of the political party even if you have more than 1/3 members. So split is not allowed. What is allowed? If you want to go outside, there should be more than 1/3 member and you should merge in any other registered political party, then and then only you will not be charged under anti defection and you will not be disqualified. Otherwise you will be disqualified, right? Again, what 91st Constitutional Amendment told, like speaker decision is definite. Speaker decision is definite, right? These were the two important things that came out of 91st Constitutional Amendment Act. Now for merger we will see one basic thing. Political party is mainly divided in two parts, legislative party and other is party wing. That is structural wing, like for example Shakha Pramukh, head of village, head of Tahsil, head of district, then the president or the founder or main person who is responsible for a party. That is, in case of Shiv Sena is Uddhav Thackeray, that is called Shakha Pramukh. Sorry, Karyaध्यksha is called, and the basic at village level is called as Shakha Pramukh. So it is divided in two parts. Now what the link of this two division? When there was split provision, there was a para number 3 in Anti Defection Law. Under this para 3, what used to do people? They used to just go with legislative. If there was split in only legislative party, and they used to come out of the, that political party and they used to form other group of that political party. In that case, they can use the symbol of that party, they can use the same structure of that polity and they will not be disqualified. But there used to be lot of cases. So in one of the case, this person went to the Supreme Court, that is Rajendra Singh Rana versus Swami Prasad Maurya. This was 2007 case. In this particular case, Supreme Court told that if you want to have split establishment of split in original political party, you need to prove that there is a split in both legislative as well as party wing. You cannot go for a split without split in political party. This was the case Rajendra Singh Rana versus Swami Prasad Maurya 2007. But what happened? What is the condition now? Now after this 91st Constitutional Amendment Act, this para 3 has been repealed. So there is no such a case as if you want to establish merger, you need to prove that there is a merger from legislative party as well as party wing, right? So same thing happened in case of Goa. There is a Gomantak party and there were 3 MLAs. Out of that, 2 MLAs merged in BJP. There was only one left, that was the president of that party, and that's why it was allowed. But in case of Maharashtra, right now, Supreme Court had said that there is a need to interpret law and constitution, then and then only we will be able to come to the conclusion whether these 16 MLAs who have rebelled, whether they can be disqualified under Anti Defection Law or not, because there is no clear cut provision whether for merger you need to establish that party wing as well as legislative wing is merged or not, whether there is a rebel in party as well as legislative wing. So this should be decided before coming to any conclusion, and that's why Supreme Court has asked for a constitutional bench, right? Got it? Now we'll come to the issues in anti defection law. What are the issues? First, there is no definite procedure. That's why there comes discretionary role of the speaker, and he will use. Then there is no time limit within which that case should be decided. So speaker, most of the time, if that decision is favoring his political party, he will take it very quick. If the same decision is going against his political party, he will delay that decision. And this discretion is used by speaker in case of Telangana, in case of Uttar Pradesh, in case of Manipur. You can give these examples to substantiate your point, right? So next important issue is with respect to speaker. So whether speaker is a political entity or constitutional office, whether it is a political office or constitutional office. What happens? There is no clear cut procedure, there is no clear cut timeline. That's why it is very difficult to say on what behalf or on what basis speaker is acting, right? So we'll see example of Manipur. In Manipur, there was a member of parliament called Shyam Kumar. He got elected from Indian National Congress, but before swearing in the assembly, he joined BJP. From INC, he joined BJP. Now, the members from INC approached Supreme Court. Now, he joined BJP and he joined ministry also, forest minister he became. So, they went to the Supreme Court. There was Yes Fali Nariman bench, and this bench invoked Article 142 of the Constitution, which give power to the Supreme Court to give any order to provide complete justice. Complete justice, right? So this power was used by this bench by S. Fali Nariman. They come up with 2-3 things. First, they restrained this MLA from entering even assembly. They asked him to stay away from the assembly. Second, they removed him from ministry. They said office of speaker is quasi-judicial, and they asked to rethink about anti-defection power enjoyed by speaker. Indirectly, this bench asked to do away with the power to the speaker given under anti-defection law, right? Next issue is now new trends. What is the new trend? You can take example of Karnataka or Madhya Pradesh. What happens usually, for example, if there are 200 strength of any assembly. So what you need is 101 votes to form government, right? But in case of 3 parties, for example, one gets 90, one gets 70, and other get 40 MLAs, right? So now there is no clear-cut mandate. So in normal case, these 70 and 40, they will come together and they will form government. But what happens? This political party, under the lure of money, it will ask some MLAs to resign, right, and recontest election on their party and get elected, right? So now what happens, for example, if 30 comes out of this particular party, so now the actual strength of parliament, this assembly will become 170, and in 170 these 90 can form government, and after forming government they can ask them to recontest and they can get elected. Same thing happened with 17 MLAs in Karnataka from Indian National Congress resigned, and this case went to the Karnataka High Court. So High Court said, like, once these 17 MLAs become disqualified or they resign, they should not be allowed to recontest remainder period, right? So this was the case of the High Court of Karnataka, but these MLAs again went to the Supreme Court, and Supreme Court allowed them to contest and said, let the public decide whether they should be elected or not, right? This was the case of Karnataka, right? Now we'll see impact of anti-defection on democracy. First, it is a subversion of election mandate, right? So for example, voters give votes to one particular member considering his political affiliations, political party, but after getting elected, when he shifts his political party, that is a subversion of elected mandate given by the public or the citizens. Then it affects normal functioning of government. See, in case of Maharashtra now, there are only 2 ministers. There is a cabinet without ministers. Then it promotes horse trading. And this might lead to corruption. That's why this second ARC has recommended partial funding for election. Then it undermines representative and parliamentary democracy, as members can't enjoy freedom to vote. Even they become accountable to political party, because if they go against political party, they will be charged under anti-defection and they will be disqualified. Again, it affects healthy, constructive debates and discussions, right? So these are the impact. Now we will see some of the way forwards. First, set procedure, fixed timeline, fixed time limit, maybe 3 months within which speaker has to take decision. Then you can follow Karnataka High Court verdict, like they should not be allowed to recontest for the remainder period. Then you can see some have recommended to remove 2/3 merger provision itself. Then again you will see whip. So power of the whip should be used in such cases. It should be binding only when there is a issue of stability of government. So when it can be no confidence motion, money bill. It should be binding only in this case, the whip, right? Then we will see Supreme Court recommendation. Supreme Court has recommended to give this power of anti-defection to President in case of Parliament and to Governor in case of Assembly, and let them take decision on the report of Election Commission of India. Election Commission of India. It will send report, and on that report President and Governor will take decision of disqualification. And this was again upheld in Kohoto Holohan case, right? Then there was a recommendation by 170th Law Commission. It recommended intra-party democracy, right? So these are one of the way forward or the solution. Now we will come to the conclusion part. How you can conclude this? You can directly say there should be constructive, healthy, free and open debates, discussions based on conscience of members to promote public interest, which is vital for vibrant democracy, right? So thank you very much. I will upload this PDF on Telegram channels. You can download this on this Telegram channel. I will send the link in the description. You can join Telegram and download this PDF, right? So thank you very much and all the very best.